members, but given the circumstances, we thought it was really important to get as many folk as possible along. So some housekeeping: we will be recording the session and you'll be able to get it on our website. If those of you who are not familiar with Teams, if you wiggle your mouse, if you have one, or put your finger on the screen, it should come up with a range of options. One, if you've got the right stuff, one of it will be a little hand, and if you're putting your hand up, that means you're asking a question. Some of you won't have the little hand, but what you'll have is a little text box, and you can text a question in. Just starts typing on that. And if you see me looking at my phone, that's because Elaine is she's sending me a text just in case I haven't seen it, if people want to ask questions. So if you could mute your microphone. I've muted everyone. Oh, everybody's muted. That's fine, thanks. Lisa, did you put your hand up?
Yeah, I did, Leslie. It was just to tell people as well, if you click on the next to the wee hand, there's like a wee show conversation, and that puts up a wee chat at the side. So it means that people can't use a hand. If you put a message there, we can see that you're wanting to ask a question.
Okay, thanks, Lisa. So you didn't come here to this room today to listen to me gibbering on about little hands and hairdos and hats and all kinds of weather. You came here to listen to Paul, and we're delighted that Paul has come along. Paul's from the Office of the Scottish Information Commissioner, and he's going to do a short presentation followed by questions. Now, that's all I'm going to say just now, and we will be taking questions after the presentation. So I'm going to just ask Paul to invite himself, and he's going to share his screen with you and just do a short presentation. So it's over to you, Paul.
Okay, great stuff. Well, hello everybody. My name is Paul Much, as Leslie said. I'm from the Scottish Information Commissioner's Office, and we're the organisation responsible for both promoting and enforcing freedom of information law in Scotland. So what I'm planning to do today is just to give you a brief introduction to freedom of information rights, and I think it's particularly important to this group here, given that housing associations, registered social landlords and their subsidiaries were brought under the scope of freedom of information law in November of last year. So they're now subject to freedom of information in a way that they weren't prior to that time. I'd also, before I start, just like to say a big thank you to Leslie and Elaine as well for getting me set up this morning. This is also my first time on Teams, and I was having all sorts of user error issues earlier on in the day, and they've calmly kind of talked me through the process. So hopefully everything will run smoothly. What I'm going to do is I'm going to share a few slides with you just to talk you through some of the basics around freedom of information. And then after that, we can get back to a discussion where we can, you'll have the opportunity obviously to ask questions, raise issues, concerns, anything that you have a question or an issue around. I'll be happy to do whatever I can to answer that. But to kick off though, and give me a second just to get this up and running. We went through this morning, so hopefully this will run smoothly. Can we see that?
Yeah, it's looking good, Paul.
Great stuff. Okay, so yeah, what I'm aiming to do is very briefly give you some information on your rights under freedom of information law, the rights that you as individuals, as tenants, as citizens have under freedom of information, not just from housing associations, but from public bodies generally. I'm also going to give you some examples of how freedom of information has been used in the past to give you a sense of the sort of things that it might be used for and it might be useful to you for. And then finish up by giving you some general tips to help you use FOI effectively. FOI is a kind of shorthand that I'll be using from time to time for freedom of information, but it's essentially one and the same thing. The first thing to say, and the most important thing to say about freedom of information, and if you take one thing away from the session today, it's that you have a right to know. What freedom of information does is it gives citizens across Scotland a right to know, a right to access information from public bodies that carry out services and undertake functions in their name. So freedom of information gives you a right to know. All you have to do is ask the organisation for information. The common situation, the common experience is that in most cases, get the information that you're looking for when you make a Freedom of Information request. One of the key underlying principles of freedom of information, of FOI, is that individuals have a right to ask. The information held by bodies that deliver public functions and public services is public information. It's paid for by us, it's paid for by taxpayers, it's to undertake work that's carried out in our name. So we should be able, as citizens and as individuals, to access that information unless there's a very good reason why the information should be withheld from the public domain. So the key underlying principle is one of openness, it's one of transparency, and it's of accountability to the public for the public services that are being carried out in their name. I've got some examples here of some comments around freedom of information from individuals and organisations, campaigning organisations who have made use of FOI in the past. And in general, we see that last year there were around 80,000 freedom of information requests made to public authorities across the year for a whole range of different activities. We see people using freedom of information for research. We see them using it to gather information to inform campaigning activity, or just simply individuals, community members using freedom of information rights to ask questions to help them understand why particular decisions are being taken, why money is being spent in a particular way, or to help discover whether organizations are working as they should in the delivery of services to individuals and communities. To give you a bit more insight on one way that freedom of information is used, I'm going to kind of provide a little bit more information in relation to the last quote there, the use of freedom of information by Inclusion Scotland. And for those that don't know, Inclusion Scotland is a charity that works to support people with disabilities. And a few years ago now, Inclusion Scotland submitted a freedom of information request to local authorities across Scotland to find out a bit more information about the availability and quality of housing for people with disabilities across Scotland. They submitted a range of different questions to local authorities in order to access information around the services, the accommodation, the quality and standards of accommodation for people with disabilities. As part of that activity and the act of submitting those questions, they found out a number of things that were of particular interest and of particular concern to them at that time. One, they found out that a number of local authorities were greatly underestimating the number of disabled people living within the local authority areas. And so the whole issue of service planning, service provision for those individuals was kind of being formulated around incorrect or out-of-date information. They asked the local authorities for information how many disabled people lived in that particular service area, and compared that with census information, and discovered big gaps between the local authorities' own understanding and the information available through the census. They also, through those requests, found out that in relation to specifically to properties, that a large number of local authorities were removing adjustments that had been made for people with disabilities when someone with disabilities had perhaps moved out of a property or had perhaps passed away, rather than looking to kind of rehouse someone with a similar disability in that property. There was a process happening around many local authorities around the country where adjustments were simply being ripped out, and then new individuals were being rehoused, and individuals were having to start the process again where someone had disabilities about looking to get appropriate adjustments being made. And again, this was obviously an issue of concern for the organisation as well, because in terms of ensuring that individuals were getting access to appropriately kitted out accommodation. As a result of the work that they've done using FOI, Inclusion Scotland were able to kind of use this information to campaign for greater involvement of disabled people in the development and delivery of local authority housing strategies. And they were able to, working with the Scottish Government, able to introduce a range of different pilot systems where people with disabilities were directly involved in the provision of services. Before I go on to tell you a bit more about what FOI is and how to use it, I just want to very briefly mention the difference between freedom of information and data protection. because both of these things are around access to information. Both of these pieces of law give individuals rights to access information from organisations. But there is a fundamental difference between them, and as a result, they are kind of separate pieces of law, separate legislation, and you would make requests separately under these two different pieces of law, depending on what it was that you were looking for. Essentially, though, and the key difference is that data protection is about you as the individual. It provides a right of access to your own personal data and sets out how organisations should be looking after your data. So if you want to access information about you as an individual, you would make that request under data protection to an organisation. Also, data protection applies to all organisations that hold individuals' personal data. Freedom of information, on the other hand, is about everything else. So if you want information about yourself, you make the request under data protection. If you want information about anything else, the request is made under freedom of information. Another key difference is that freedom of information only applies to organisations that carry out public functions, public services. So it doesn't apply to organisations like banks, like shops, retailers, who are covered by data protection. So those are the kind of two key differences, but I think it's kind of important to set that out at this point, just so that you're aware of what those differences are. So as I've said, FOI applies to Scottish public authorities in Scotland, and also there's similar legislation across the rest of the UK. So that includes, for example, organisations like the government and Parliament. It includes all 32 local authorities in Scotland, the NHS, the emergency services, colleges and universities, and a range of other organisations like the Scottish Environment Protection Agency and the Scottish Housing Regulators covered by freedom of information. And also, as I mentioned recently, from November, registered social landlords, housing associations and subsidiaries were brought under the scope of freedom of information. And I'll say a little bit more about that in a moment. But to give you a bit more information about your rights, freedom of information requests, to make a freedom of information request, your request has to be made in a recordable format. So to access information from an organisation, you have to ask for it in either email or writing, or an audio file. Recording something and sending it off would work in the same way as well. But the important thing is that it has to be made in writing. So a request over the telephone or verbally over a counter wouldn't qualify as a freedom of information request. You'd have to jot it down in writing and submit it. You also have to include a name and an address for correspondence, and obviously you have to set out what information it is that you're looking for. But provided you do that, you will have made a valid freedom of information request to an organisation. You don't have to tell the organisation why you want the information. You also don't have to mention freedom of information when you make a request. So any point at which you contact a Scottish public authority in writing asking for information, that request will carry freedom of information rights with it. Freedom of information covers recorded information only. So it covers information that's recorded and held and stored by an organisation. So it doesn't require organisations to create new information in order to respond to you. It doesn't require, the contents of someone's head, or a conversation between two people wouldn't be covered unless there was a recorded record of that conversation. What it does cover, however, is very, very broad. So it's anything that's recorded and stored and held by an organisation. So that includes information recorded in paper files, information in minutes of meetings, electronic information. It includes data stored in spreadsheets, correspondence between individuals, handwritten notes that are jotted down at a meeting would be covered by freedom of information. It even covers information stored in audio cassette or CCTV or audio files. Anything that's physically recorded and held by an organisation is covered by freedom of information, and you can request it under the legislation. It's important just to briefly mention something about housing associations and FOI as well, because for most organisations, when an organisation is brought under the scope of FOI, it covers everything that's held by that organisations. There are some limitations in the order that brought housing associations under the scope of freedom of information that limits what's covered to the public functions that are carried out by housing associations and their subsidiaries. So it covers information on the services that they provide in relation to the prevention and alleviation of homelessness, the management of social housing accommodation, the provision and management of sites for gypsies and travellers, for example. But it doesn't cover information on kind of non-public services that are carried out. So it doesn't cover requests for information on services for owners and occupiers of houses or the management of non-social housing accommodation. So that's just something to bear in mind in thinking about making a request to a registered social landlord, to a housing association. When you make a Freedom of Information request, the organisation is duty-bound, they're required by law to respond to you as soon as possible and within 20 working days. Working days excludes weekends and public holidays. Authorities, organisations also have a duty to advise and assist requesters. They have a duty and a responsibility to help people out who are seeking to make information requests. So you can ask them for advice on making a request prior to doing so, or at any point in the request process. You can pick up the phone. The request has to be made in writing, but you can pick up the phone and ask for help, or you can just ask for general help and guidance. And they have a duty under the legislation to provide you with that advice and assistance. They also have a duty under Freedom of Information to publish information. So it's not just about you requesting information from an organisation. They're encouraged to publish a whole range of information proactively in the public domain. So since registered social landlords were brought under the scope of Freedom of Information, they should have added a whole range of additional information to their websites, proactively publishing information in the public interest so that you can access it in many cases without having to make a request. If you do have to make a request, though, it's worth noting that most requests are responded to in full and on time. So most requests are responded to, absolutely within the 20 working days and in full. The common experience is, from the data that we get back from public authorities that are covered by FOI, is that if you make a request, in 75% of cases, the requester gets some or all of the information that they're looking for when they make a request. From the recent round of data that we've gathered, we actually found out that that figure was even higher for registered social landlords from the first submission of data that they told us about since they came within the scope of FOI. It was 81% of requests made to registered social landlords were responded to with the information being provided, which is great news and a great start for RSLs in terms of fulfilling their duties under the legislation. Information can be withheld in certain circumstances in response to an FOI request, but only in certain circumstances. So there will be cases where you don't get the information that you're looking for. In some cases, that might be because the information isn't held by an organisation. If they don't have it, as I mentioned, they're not obliged to create it to provide it to you. It might be because the request costs too much. So if it costs more than £600 for the organisation to respond to your request, they are entitled in those circumstances to refuse your request. There's an exception if what you're looking for is environmental information. There isn't a kind of defined cost limit if you're looking for environmental information, but generally they can refuse requests that cost more than £600 for them to respond to. Requests can also be refused if an exemption applies, and there's a limited number of these in the Freedom of Information Act that allow organisations to withhold information. They include, for example, if the disclosure of information would substantially damage an organisation's commercial interests, then it might be that the information will be withheld in those circumstances. If it would harm law enforcement, then again, information can be withheld. Or if it's someone else's personal data that you're asking for, and giving that information to you would breach their rights under the Data Protection Act, then again, they're entitled to withhold the information in those circumstances. But it's worth mentioning as well that in many cases, there's a public interest test that's in place. So that in many cases, even if an exemption applies, the organisation still has to consider the public interest and release the information to you if it's in the public interest to do so, if the public interest in releasing it outweighs the public interest arguments in, for example, maintaining an organisation's commercial interests. So if it's really substantially in the public interest for the information to be disclosed, then normally, under normal circumstances, that information would be disclosed. There are also things that you can think about if you do get a refusal. So if the information isn't held, then you can think about what other useful information might be held. And remember, an organisation has a duty to advise and assist you, so they should be telling you what sort of information they hold that might be helpful to you. And you can give them a prompt in that regards as well if you don't feel they're being as helpful as they might be. If the information request costs too much, then you can think about whether your request can be narrowed. Are there things that you can do to narrow the request, like introduce a time frame, for example? So if you asked for everything on a particular subject, you could ask for everything within the last year or last 6 months on that subject, and that might help bring it within the cost limit. And again, the organisation should be advising and assisting you, and you can prompt them to advise and assist you in those circumstances as well. If an exemption applies, then it may well be that there's other information that can be provided. And it's worth noting that just because an exemption applies to some information in a document doesn't mean that everything in that document can be withheld. What the organisation should be doing in those circumstances is just blacking out the exempt information, but providing you with the remainder of the information. So it might be, for example, that information can be provided with names of individuals blacked out, as long as the individuals aren't identifiable from other information that's in that document. And the other thing to mention is that if you do get a refusal, and the common experience, as I've mentioned, is that you won't get a refusal. But if you do get a refusal and you're unhappy with the reasons that the authority gives you, then you have a right of appeal. You can appeal against a decision, and ultimately that appeal comes to our office, and we enforce freedom of information law. We investigate cases where requesters are unhappy, and we can, if we find that an organisation has inappropriately in withholding information, we have the power to require the release of that information to you. And I would just stress as well that if you are dissatisfied with the reason that's given to you, then it is really worthwhile appealing to us. We find that in the appeals that come to us, around 64% of the appeals that we deal with find either wholly or partially in the requester's favour, meaning that you either get all the information that you asked for, or you at least get some of the additional information that you've asked for. We might find that an organisation was right to withhold some information, but other information should have been provided to you, and we can require the disclosure of that information. When I was pulling together some information for this, all the decisions that we issued on appeals that come to us are published on our website in our decisions database. I had a quick look just by typing in that database for the sorts of things that come under the umbrella of housing, just appeals that have been made in relation to housing. And this is just a quick screenshot of the return that we got from the decision database there. And I've just included this just to give you an idea of the sorts of things that individuals have come to us on appeal about in the past as well, to give you an idea of the sorts of things that other people have been using freedom of information to access information on in the housing field. So we see, for example, there requests relating to improvement works at properties, someone looking for information relating to those works, heating renewal projects, again, information relating to housing repairs, communications between individuals and organisations. So one there between a housing association and the Scottish Housing Regulator, someone looking for communications between those organisations, contract tendering issues, minutes of meetings, allocations is something that we've seen come up from time to time. Land ownership, land maintenance issues. Again, these are the range of things that we've in the past seen appeals coming to us in relation to those sorts of issues. So that's just to give you a sense of the sorts of things that others have been using freedom of information for, to give you an idea of how the rights might potentially be helpful to you. So I'm just going to finish up the kind of presentation section of this session just by giving you a couple of hints and tips from our experience in the past, from how others have used freedom of information, just to help you think about how you might use it effectively. And the first thing I just want to mention is that, as I've said, organizations have a duty to publish information. So before you make a freedom of information request, it's always a good idea just to think, ask yourself whether the information might already be available. Have a quick look on the organization's website, just to check whether the information that you're looking for is already published. In many cases, as I've said, organizations are required to publish a lot of information, so there is a really good chance that information may well be out there. If you do find that you have to submit a request, remember that FOI covers recorded information. So try and frame your request in a way that seeks access to recorded information. That might be, for example, asking for copies of minutes of meetings or reports or documents, spreadsheets, meetings between individuals, correspondence between individuals. But if you can kind of hone your request down to information that's likely to be recorded, you're more likely to receive a positive response. Try and be as specific as you can when you make your request. Try and kind of tailor your request specifically to the information that you're looking for. It helps you get what you want. It also reduces the likelihood of a request being refused on cost ground, and it minimizes the impact on the organization as well. It means that they can focus their request on the their response on the information that you're really specifically interested in. And remember, you can take advantage of the duty that the organization has to advise and assist you by having a quick chat with the organization before you make your request as well, to get a sense of what sort of information they might hold or the format that they might hold it in. In order to be specific, as I've said, it can be helpful to provide a time period, so to limit your request to a particular period of time, to again help hone and focus the information that you're looking for to the specific time period that you're interested in. Again, this is fairly common sense advice, but it's always a good idea to read through the request before sending it. Try and put yourself in the shoes of the individual receiving that request. Will it be clear to them what it is that you're looking for? Is there anything that you can do to make that request clearer to someone picking it up, to help them understand what you're looking for and to help them provide you with the information that you're seeking access to? And finally, keep copies of any documentation. Keep copies of the requests that you make to the organization. Keep copies of any responses that you get from them. As I mentioned, most requests are answered in full at first time at the point of asking. But sometimes you might not get what you're looking for. Sometimes you might want to appeal to our office. So if you do that, then you will need to provide us with copies of the correspondence as well. So again, we strongly recommend that you hold on to those in the unlikely event that you do need to take an appeal to us. And lastly, and again, I shall provide a copy of the slides and notes from this session to circulate to TPAS afterwards. But I've just included a couple of URLs there for pages on our website that I think might be particularly useful to anyone looking for more information. There's the Your Rights section of our website there, which is the first link, which has information on everything that I've covered, but in slightly more detail, talks you through the process of making a request. We also publish a page with tips for requesters to help you formulate your request, to kind of hone the wording of your request, to give you some advice in terms of framing a request to submit to an organization. And if you're interested in hearing more about how other people have used freedom of information, and I mentioned briefly the experience of Inclusion Scotland earlier in this session, but we have a number of case study videos that we've published there as well, with people from a range of different backgrounds talking about their own experiences using freedom of information and the impact that using freedom of information FOI rights had on them and their campaigning activity or the pursuit of their personal interests. And they can be really useful just to give you a sense and an idea of the range of things that FOI might be used for and the sorts of things that you can ask for. But that really kind of brings me to this formal session. Let me just see if I can come back. Hello?
Hey, Paul. Hi.
Can you, am I back on screen? Can you see me?
Well, I can see, I think there's quite a lot. Yes, you're coming back onto our screen again. So thank you very much
there we
for
go.
that.
There's my camera.
Yeah, thank you very much for that. That was very informative. I have to admit, put my hand up. I knew well very little, and you've provided a lot of clarification. So thank you so much for that. And I would expect that we're going to get some questions. So can I throw it open to questions, please? Oh, here we are, John.
Thank you, Paul. I'm John Houston. I'm one of the tenant participation officers at Fife Council. I'm also the editor of our Down Your Street magazine. It's our tenants magazine that goes out to our 30,000 tenants. I think our tenants would be really interested in an article from yourselves detailing and outlining who you are and what you do, similar to some of the information that you've put out in the presentation, which was fantastic. I think it would be great. And what I'm looking for is a kind of 2-page article, and we could get that into the next edition of Down Your Street. I don't know if that's something that you would be happy to do. And again, that article, that information could be circulated across the other LAs for inclusion in their magazines, because I know there's a number of LAs that have their own magazine. So.
No, absolutely. I mean, I'd be very, very happy to provide that. So yeah, I mean, it's something that I think Leslie and I were discussing prior to the pandemic hitting, and I think it's kind of been sort of sidelined or delayed a little bit just as a result of trying to kind of cope with the challenges that have been thrown up in recent months.
Sure.
But no, I'd be very, very keen to do something like that. So absolutely. What I'll do is I'll share my contact details after this as well. And if you can just drop me an email just with kind of any information on kind of, you know, word count, deadlines, that sort of thing. Sure. And I can ensure that we draft something to get that out to you. Because yeah, I mean, we're very, very keen to ensure. We did a lot of work prior to the RSLs coming on scope with freedom of information, did a lot of work kind of working with RSLs to ensure that they were prepared and ready to meet their freedom of information duties. And we're keen as well to ensure, you know, subsequently now they are on stream, to ensure that tenants, individuals, communities are aware of their rights as well, you know, filling in the other side of the circle too, so that they can take advantage of those and whenever they find themselves in a situation where they need to use them. So absolutely, anything we can do to support that would be very, very keen to.
Thank you.
Thanks, Paul. Do we have any more questions? Any more hands up there? Oh, Alistair. Alistair, you'll need to unmute. Okay, and Jeff, I see you sitting there. Alistair, on you go.
Yeah, well, just very briefly, is there currently a cost to the for a freedom of information request, and what about confidential information, like if you're requesting the minutes of a board meeting and when the meeting goes into private and confidential, are these withheld as well, or do they get submitted?
Sure. Okay, well, first on the cost issue, for most people, no, there won't be a cost to submitting a freedom of information request. Most requests are answered with the provision of the information with no charge being levied. There are certain circumstances where organisations are allowed to charge. So I mentioned that requests that cost more than £600 for an authority can be refused. If a request costs between £100 and £600, an organisation is allowed to charge 10% of the cost to it of responding. So they are allowed to charge in those circumstances. If it costs less than £100, then they're not allowed to charge. Between £100 and £600, they can charge 10%. But the common experience is that most organisations won't charge in those sorts of circumstances. I mean, they do from time to time, but mostly organisations will just respond to the request unless they hit the £600 upper limit. We don't see fees notices being issued that often. One thing I did mention earlier was the situation with regards to environmental information. There are different rules governing access to environmental information. So information relating to the condition of a building, for example, would fall within the scope of the environmental information rules. The environmental information regulations don't have an upper cost limit. and they do allow an organisation to charge the full cost to them of responding to the request to the individual. But it's up to an individual whether they pay at that point in order to receive the information. But alongside that, we also find that most organisations follow FOI rules in relation to the environmental information regulations and won't charge, unless it kind of reaches the £600 limit, and then they might start thinking about charging. But so the common experience is no charge, but there may be some circumstances where you are asked to pay a small proportion.
Great, thanks, Paul. Jeff?
The second part, sorry, I'll just quickly address the second part of that as well, which was around access to confidential information in minutes of meetings. Ultimately, information can only be withheld if it falls within the scope of a Freedom of Information Act exemption. So you can't just mark information as confidential and then automatically withhold it in response to a request. You have to look at the specifics of the information that you're seeking to withhold and decide whether it falls under the scope of one of the exemptions in the Freedom of Information Act. Now, often, information that you're discussing in a confidential section of a meeting, there will be very good reason why that's being discussed in that section. It might be because it involves sensitive personal data or just personal data of individuals. It might be because it's highly commercially sensitive. It might be because disclosure of the information in the public domain would result in an actionable breach of confidence, which is another one of the Freedom of Information Act exemptions. You can withhold information if disclosure would be an actionable breach of confidence, but that means that it would have to be actionable in a court of law. And there are tests that organizations would have to apply in order to apply that. So, I mean, it is a good idea to kind of, discuss information that is likely to fall within the categories of exemptions in those confidential sections of meetings, and obviously not publish those minutes proactively. But if you got a request, if an organization got a request for information that was dealt with within that confidential section, they would have to look at the specific information in terms of the Freedom of Information exemptions in order to decide whether it's right to withhold it.
Okay, thanks, Paul. Jeff, you've got your hand up.
Yeah, can you hear me all right?
Yes,
yep.
Thanks.
Okay. If all else fails, what's your ultimate sanction against the people who've been requested this and don't comply?
Okay, well, what we do, someone makes an appeal to us, we conduct a full investigation. So we get all the information that's held by the public authority relating to the case. We consider it and we decide whether they acted appropriately. Where we find they haven't acted appropriately, we issue a formal decision, which kind of basically tells them why they haven't acted appropriately and requires them to take action. If they don't take action, if they don't kind of follow the steps of that, then we can enforce that decision in the court of session. So we would go to the court of session and enforce that decision with them. Now, it's never come to that. We've never had to do that as yet. Organizations do comply with our decisions. They also have a right of appeal against our decisions, and from time to time we have had organizations appeal our decisions which have gone to court as well, but generally when we issue a decision, organizations will comply with that decision. Failure to do so can be treated as a contempt of court. So yeah, it's also worth mentioning as well that if an organization destroys or deletes or hides information in response to a Freedom of Information request, then that is a criminal offence under the legislation. So that can be referred to the police where we find evidence of someone having concealed, withheld information in order to prevent disclosure.
Okay, thanks for that, Paul. I think Hannah, you've got your hand up.
Yeah,
Hi,
I put a couple of questions just in the chat there. So what do you find is the biggest barrier to people kind of getting the information they're looking for? And then kind of related to that is, are there any things which consistently come up as reasons for not providing information?
I suppose the biggest barrier to people using their FOI rights, I suppose a lot of the time is kind of awareness. We do have very good public awareness of freedom of information in Scotland. I mean, it's around about 85%, I think, at the moment, members of the public who say that they're generally aware of freedom of information. Maybe drilling down into the detail of what it actually means, you know, people are less clear on that. But in terms of awareness of the term and that there is a freedom of information right, we have generally good awareness. But I think people often kind of, you know, have difficulty sometimes in seeing how that might apply to their own particular situation. And sometimes, you know, from us having the conversation with individuals, you know, we will say, have you thought about requesting this from the organization, or do you know that you've got rights to request this information? Then that can often, you know, you can see sometimes scales falling away for people as they begin to think about how FOI might be useful and helpful to them. And that, I think, is why looking particularly at the case studies and examples of how people have used freedom of information in the past can be really, really useful in terms of thinking about how it might be helpful to you. So in terms of barriers, in terms of reasons for refusal, I suppose one of the most common, in fact, the most common reasons for refusal that we see, or reasons for people not getting what they're looking for. Number one, the most common one, is that the information isn't held by an organization. So people are asking for information that an organization doesn't hold. Now, you can appeal if you disagree with that. And we do see cases where organizations tell people they don't hold information. We will step in and conduct an investigation and find that sometimes actually information is held. So it is well worth appealing if you're not sure of the reasons for that. Apart from that, where information is held, the most common reason is personal data. So where information is someone else's personal data, then, and release would breach personal data rights, then that's something that we see coming up quite commonly as well. But those are kind of the most common issues that come up.
Okay, thanks, Paul. We've got Francis McGonigal. Francis, are you there? Hello, Francis. Francis? No. You unmute, Francis.
I can see that there's a question there from Francis in the chat, so I could respond to that if that would be
helpful. Yep, thank you. Yep.
She's asking whether people find that they're mainly happy with the response, or is there a problem getting information firsthand? Well, as I mentioned, the common experience is that most people get at least some or all of the information that they're looking for. Now, we only, find out about people's dissatisfaction when they make an appeal to us. So, you know, when people go through the process of making a formal appeal to us. And I mentioned that around 80,000 FOI requests are made across Scotland each year. Of those requests, only around 1% of requests are appealed to us. So that kind of find their way through to an appeal to our organisation. Now, we're not quite sure why that is. It might be because people are happy with the response. And I'm sure in most cases it will be because people are happy with the response. In some cases, it might be because people aren't as aware as they might be of their right of appeal. And they should be getting told about their right of appeal in the responses that they get from organisations. But, you know, it may be that people aren't, don't fully follow through on that, or people just decide to, give up at that point as well. So, but what I would say is that generally the data indicates that most people are satisfied. Most people get what they're looking for, and they're satisfied with what they get. I'm sure there are some people who are unhappy but don't go on to lodge an appeal with us. But as I also mentioned, around 1% of people do go on to follow through that process and make a formal appeal to our office. And if they do, as I said, around 64% get at least some additional information as a result of that appeal.
Okay, thanks, Paul. Lisa, you put your hand up.
Hi, Paul. Yeah, I just wanted to ask about the right to appeal. Is there a time scale for people appealing?
Yes, if you're looking to make an appeal, it has to be made within 6 months of the response that you get. There's actually, I haven't gone into this in too much detail in the presentation just because of the constraints of time, but there's actually a 2-stage appeal process. So what you do is you make a freedom of information request. The organisation responds to you. If you're unhappy, the first stage of the appeal is to go back to the organisation, tell them that you're unhappy, and ask them to reconsider the way that they dealt with your request. You have to do that before you can bring a formal appeal to us. If you do that, they then have another 20 working days to reconsider their response. It should be someone more senior in the organisation who wasn't involved in the original decision who conducts that review. They then respond to you within 20 working days, and at that point, if you're unhappy, you can bring a formal appeal to us. But there's more information on all of this process on our website. So do feel free to take a look at that. We also have an inquiry service as well that you can contact, and there's details of that on the slides that I'll circulate after, so you can get in touch with us with any questions relating to any stage of the process.
Okay, thank you.
Susie, you've got your hand up.
Yeah, hi. I was just following on from Alistair's question about cost and cost exemption. And I was just wondering if we, as a landlord, got one person asking lots and lots of questions, like when could you apply that cost exemption? Would it be to each individual question, or would it be to the whole thing?
Yeah, it has to be applied in relation to each individual request. You can't kind of aggregate responses from a particular individual and kind of, come up with a cumulative total. So it has to be applied in relation to each individual request. The one thing that I, again, for time reasons, I didn't mention during the session as well, though, is that there is provisions in freedom of information to refuse requests if a request is repeated. So if someone's asking for the same or fundamentally the same information as they previously asked, you can refuse on that basis. There's also the ability to refuse a request if the request is vexatious. So if someone is using freedom of information in order to clog up the workings of an organization as part of a campaign, rather than to genuinely access information, then you can look at the vexatious provision that exists in freedom of information there. But I should mention that that is a high test that has to be met there. So in order to apply that provision, so it's not just someone who's vaguely annoying. It has to be, you have to be able to clearly demonstrate that the purpose of making an individual request is to vexate the organization rather than to genuinely access information. And we have guidance and briefings on the use of that exemption on our website. But yeah, in terms of cost, you do have to look at individual requests on an individual basis. But the other thing to bear in mind as well is that if you are getting a lot of requests for a particular type of information, then what to think about there is, can we just publish this information? Can we just put this up on our website? Then we don't have to respond to requests for that information. If someone's asking it repeatedly for the same sort of thing, but maybe on a monthly or basis or whatever. So.
Okay, thanks for that, Paul. Is there any more questions? John, is that you? Yep. John, unmute.
Yeah.
There you are.
Sorry. I was just thinking there when you were chatting, Paul, having been on the other end and trying to decipher what people are asking in the request, it can be an absolute nightmare. Mm-hmm. And you said, most of the organisations they come from a good place. They're trying to read between the lines and assist. And I know that that's been my experience working in Fife Council, but it's not always easy. And for me, I think it's a really daunting experience for tenants when they're genuinely trying to get data from us. And they've maybe tried to get around our website, and sometimes that could be a hit or a miss on any given day. But the process of actually trying to figure out how to put it down on paper and, make a coherent request for the data, that is quite challenging for a lot of our tenants. And I'm wondering, in terms of your website, is there any information that you have, maybe in a video format or in a particular way, that actually helps people start to create that process? And again, that's something that we could utilize to then share.
Yeah, absolutely. We try and do what we can, and I'm well aware of the sorts of issues that you're discussing, and there are challenges that we see when appeals come to us as well, where sometimes it's maybe not immediately clear what the requester is looking for, or the way that they've expressed themselves hasn't actually resulted in a request for the information that they were actually seeking. So absolutely, those can be challenges that do come up from time to time. We try and do what we can to address that. I mentioned that we've got tips for requesters, pages on our website. We also have got a series on the Your Rights section that I included a reference to in the presentation, and I'll include a link to in the slides as well. There are kind of short infographics that we've created in relation to the animated infographics in relation to various aspects of freedom of information law to help people understand their rights, and they can be kind of used and embedded, you know, in your own materials if you would find it helpful as well. So again, you know, feel free to take advantage of that, and I can you know, talk you through the process of kind of using the code for that if there's any issues with that. The other thing I would say as well, in terms of managing those requests from the perspective of an organization responding to requests, think about the points of contact that you have with individuals as well, and doing what you can at those points to make people aware that you have a duty to advise and assist them. And, you know, if they are unsure about how to frame a request, you know, you can include contact details there to talk through, you know, what sort of information you hold and how you hold it prior to making a request to kind of support them in doing so. And the other thing is as well that we also appreciate that sometimes the relationships between requesters and organizations can be a little bit strained at times, you know, in order to lead to the request as well. So do feel free in those sorts of circumstances to refer individuals on to us as well for advice on making a request, or, you know, advice on, you know, often, you know, as a kind of independent, objective kind of, you know, a third party, it can help to diffuse some of those tensions that sometimes exist, where maybe an individual, you know, doesn't necessarily believe that you have their own best interests at heart in the advice that you're providing, which can happen from time to time. So again, yeah, feel free to refer people on to us as well.
Brilliant, thank you.
I think, Jeff, you have the honour of having the final question. Jeff Morgan, you got your hand up? You unmute, Jeff. We can't hear you. You need to unmute your microphone. No, if you wiggle your mouse.
Happening.
Yeah, you've got you now. On you go. Okay, Jeff.
Just keeps coming back. It just keeps coming back.
We can hear you now.
Is that okay now?
Yes, that's grand, thanks.
Yes. What do you do when the person designated to reply to your request, it becomes obvious that they haven't a clue what you're talking about?
Well, I suppose there might be, yeah. I mean, there might be a kind of a few issues behind that. I mean, I think, I suppose what I would suggest there in those sorts of circumstances is you would remind the organization of its duty to advise and assist you. And I think it can be really helpful in those sorts of circumstances to have a conversation with someone in the organization. I mentioned that freedom of information, the actual formal process of making the request has to be done in writing. But there's nothing to prevent you kind of, you know, having a conversation either before you make a request or during the request process, or even after information is being provided to help you understand what's been provided. And you can certainly remind organizations of their duty to advise and assist you in those circumstances as well. But certainly there can be times where, you know, the way an organization holds or describes information isn't the same as the way that you as a requester might kind of, you know, describe it yourself, and that can sometimes cause a little bit of conflict. So having a conversation with a kind of, you know, an individual can really help to diffuse those issues from time to time. So that's certainly an option. The other thing to say is that when an organization gets a request and it's not clear what's being asked for, there is a provision in the legislation relating to clarification. So the 20 working day timescale won't start until they have a request that's clear. So there's a provision that allows them to seek clarification from you, and provided it's reasonable for them to do it, they're entitled to do it. And that then kind of begins the process of them getting clarification that enables them to respond. But again, I mean, going back to the heart of all this, you know, and one of the things that we said to housing associations during the training is to kind of you know, FOI is a legal process, but also we really stress that they should also be thinking of it as a customer service process. It's about engagement with customer service, and they should be looking at it through a kind of customer service prism about engaging with tenants and communities, and look at the duty to advise and assist from that perspective as well. So hopefully, you know, they will be doing that, and they will be doing what they can to support and advise you to make a valid request.
Thanks very much for that. Thanks for your question, Jeff. I think we've come to the end, and I don't know about everyone else, but I certainly knew very little at the start. I know a whole lot more now, and it was very well put across, Paul, and very easy to understand. So thank you so much for that. As I said, and Paul said, his slides, we'll be making his slides available, and Elaine can send them out to everybody. So on that note, thank you very much again, Paul. And
that's great. Thank you.
Thank you. And thanks to everyone for coming along. And hopefully we'll see you on the 20th of August. And just a final reminder about Tenant Voice Scotland, if you go onto our website, and then you can sign up for that. So thanks, everybody. Have a lovely Glasgow Fair weekend, if that applies. I don't think it applies to you in Orkney, Susie, or you in Fife, John, or Aberdeen, or anywhere else, just in Glasgow. So thanks, everybody. And well done.